Supreme Court today scrapped the OBC reservations to Jats, saying caste, though a prominent factor, cannot be the sole factor to decide backwardness. The court, while setting aside the then UPA government's notification of the 4th of March 2014, said possible wrong inclusion of a caste in the OBC list in the past cannot be the basis of further wrong inclusions.
Supreme Court has quashed the notification to include Jats in the central list of other backward classes for according benefits of reservation to them. The judgment was pronounced by a bench of Justice Ranjan Gogoi and Justice Rohitan Falinariman. Giving the judgment, the court set aside the notification to implement Jats in the central list of other backward classes. The court found fault with the centre's decision to ignore the findings of the National Commission for Backward Classes, which said that Jats need not be included in the central list of OBCs as they don't form the socio-economic backward class. The court found fault with the centre's decision to ignore the findings of National Commission for Backward Classes, which said that Jats need not be included in the central list of OBC as they don't form socio-economic backward class. Coming down heavily on the erstwhile UPA government, court opined that caste cannot be the sole factor of determining backwardness of a class. It also said that a wrong inclusion of a class in the past cannot be a basis for further wrong inclusion, and that inclusion of a politically strong class would adversely impact the welfare of other classes. The decision came on a PIL filed by the OBC Reservation Raksha Samiti. The erstwhile UPA government had issued notification just before the Model Code of Conduct for the general elections came into force.
Court has categorically mentioned that no political class and no political caste can be given a reservation on the basis of that they can mobilize the politically a particular government. That there has to be a exclusion, not only inclusion. There cannot be a ground of comparison being a caste in the backwardness.
The incumbent government has also supported the decision to include Jats in the OBC list. Meanwhile, the Jat community leaders have already decided to have a legal recourse. They also want the union government to bring in a legislative remedy.
सुप्रीम कोर्ट का हम आदर करते हैं, लेकिन हम इनसे एग्री नहीं करते। इनका जो फैसला लिया है, इससे हम टोटली जो है सहमत नहीं है, हम अगेंस्ट हैं। हम इसका रिव्यू करवाएंगे, अपील करेंगे।
The political parties too seem to be united in their support for the Jat reservation. Cutting across party lines, they openly express support for the matter.
इनकी जो सामाजिक, शैक्षणिक और आर्थिक स्थिति ओबीसी की तरह ही है, पिछड़ी हुई है, इसलिए हमारी पार्टी शुरू से ये कहते रही है कि जाट समाज के लोगों को ओबीसी में शामिल करके इनको आरक्षण की सुविधा देनी चाहिए।
जाटों में भी बहुत गरीबी है, उस सबको ध्यान में रख के दिया गया था तमाम लोगों को, लेकिन ये कि अगर सर्वोच्च न्यायालय ने उसको रद्द कर दिया है तो हम आगे क्या तरीका हो सकता है, क्या कोर्स ने, ये हम देखेंगे।
सोशली, कल्चरली और इकोनॉमिकली जाटों का बड़ा हिस्सा आरक्षण के अंदर आता है। सरकार को पहल करनी चाहिए और सभी जो इसमें इन्वॉल्व हैं सेक्शंस, उनको इकट्ठा करके फिर कोई कंसेशन बनानी चाहिए।
Some Jat leaders, meanwhile, are already suggesting that the government should appeal before a bigger bench.
कोर्ट का फैसला है और आरक्षण जहां तक बात है, जाट डिजर्व करते हैं, उनको मिलना चाहिए। सामाजिक पृष्ठभूमि के आधार पे भी जो फैसला हुआ है उसके विरोध में जो जाट संस्थाएं हैं वो अपील में जाएंगी और मुझे लगता है कि न्याय मिलेगा।
बड़े आंदोलन के बाद जाटों को ये अधिकार मिला था और सब किसान जातियों को भी ये अधिकार मिला हुआ है, वो भी जाति के आधार पर ही मिला है। तो हम एक रिव्यू पेटिशन करेंगे।
Jats are included under the OBC list in Bihar, Gujarat, Madhya Pradesh, Uttarakhand, Delhi, Rajasthan, UP, Haryana and Himachal Pradesh. The current ruling necessarily means that the state governments may continue to accord them OBC status and the reservation benefits that accrue subsequently for state government jobs. The same will not be applicable for jobs in the central universities and central government jobs. The next course of action for the government would necessarily be a legal review of the case before deciding on any future step. Newsnight Desk, DD News.
And the big question of the hour is, did the urgency to implement the reservation ultimately lead to its quashing? That's the big question. As you can see there on your screens, did the urgency to implement reservation for Jats ultimately lead to its quashing by the Supreme Court, which happened today? And for more on this topic, we are joined in the studios by our special guests, Mr. Vipul Mudgal, who is a sociologist as well as a senior journalist. A very warm welcome to you, sir. And Mr. Sandeep Mohapatra, who is a senior advocate of the Supreme Court. A very warm welcome to you, sir, as well. Well, as you just saw, the top question, the question of the hour is, did the urgency, to implement this reservation ultimately lead to its quashing? Your very brief observations.
I think definitely. I mean, it was brought in at a time when elections were right there. It was one day before the Model Code of Conduct kicked in. So, I mean, the timing was absolutely wrong. But I would say that Supreme Court has cleared a very big imbalance. They have the muscle power, they have the land holding, they have the political power, they have the clout, they even have the jobs. And in fact, wherever they were given reservation, like in Rajasthan, one saw that the entire list of OBCs, which had about 80 odd castes, they usurped all the jobs. They were taking up to 80% jobs were going to highly qualified Jat candidates. So I think this was an imbalance, and Supreme Court has done a great job.
Right, but well, we are hearing more noises after that, various reactions from the Jat community. We'll come back to that later on. But first of all, Mr. Mohapatra, as a senior, somebody who's well versed with the legal implications, we'd like to know from you, what does the Supreme Court decision mean? Are we looking at very long-standing implications here when it comes to reservations?
Definitely, like the Supreme Court has, I would say, in my reading of the judgment, has followed a 9-bench judgment of the Supreme Court itself, which was given in 1992 in the case of Indira Swane. And in that case, it was very specifically mentioned that when you are looking at reservation or including some new groups into the reserved category, you have to follow certain norms. And in passing this judgment, the Supreme Court has relied on that particular judgment. And that particular judgment also led to the formation of the NCBC, the National Commission for Backward Classes. And the NCBC is a statutorily governed body, and the statute that defines the NCBC also provides that the NCBC has the power to look into complaints, look into petitions to be included or to not to be included in the backward class list. In this case, that has precisely happened. In 97, the NCBC gave a view that except for some Jats in Rajasthan, it did not include other Jats in other states. In 2010 again, an attempt was made in Delhi, and that was rejected. However, the government of the day in 2011 gave review power to the NCBC and asked the NCBC to review it. The NCBC, after conducting 2 public hearings during the 2011 to 2014 period, on 26th of February 2014, the NCBC gave a report saying that Jat cannot be included in the backward class category. However, going against the NCBC report, going against the statute that mandates that the government has to follow the recommendations made by the NCBC, the government in a very hurried manner, as Mr. Mudgal has pointed out, on 4th of March, set aside, so to say, the recommendations made by the NCBC, though they are not supposed to do that unless there are pressing circumstances. And the ground that was provided by the government is that NCBC apparently did not take into consideration ground realities. So what ground realities mean, nobody knows. And 5th of March, as we all know, the Lok Sabha elections were notified, and on 4th of March, this notification came out. So this was the background in which the notification came out, notifying Jats.
Right, so again we come to the statement that we made right in the beginning, that it was the urgency of implementing this process of reservation that ultimately led to its quashing. So you agree with that?
Yes, to some extent, yes. But at the same time, you will also have to see as to what are the legal parameters. Because the constitutional scheme is such that Article 15 and 16 says that other backward classes have to be provided with affirmative power. But who constitute the other backward class?
Right.
That has to be determined by a statutorily appointed body, that is NCBC.
True.
So if you don't follow the due process, you have to meet this fate, and
True.
that's what has happened to this notification.
Right, right. We'll come back to that later. But coming to you, Mr. Mudgal, politically, what does this mean? I mean, in this decision, tell us about the impact, in terms of gains and losses to the various stakeholders.
You see, it's quite simple. The Jats have the numbers. In western UP, in Rajasthan, in parts of Madhya Pradesh and parts of Delhi, particularly outer Delhi, they are large in numbers. And that is why all political parties cutting across. I mean, I'm very surprised that there's no difference between Congress and BJP and even Mayawati in in UP is supporting them. It's only because they have the numbers. There is no other reason. In fact, if you see there are ways in which you can actually calculate and see how much of the OBC quota has been taken by the Jat candidates. I was told in one particular case in Rajasthan, the entire judicial appointments, the subordinate judiciary, wherever this thing was, it was literally almost 70%, 80% appointments in one particular year were of Jat candidates.
So to what extent would you say the promise of reservation, it actually reflects the genuine demands of the community?
I tell you, you see what happened in Rajasthan after that. You see, there are two things. One is, see how reservation has worked in India for the first 40 years until from 1947 to say from 1950 to 1989 until Mandal Commission came. There was no problem with reservation. I mean, people understood that it's being given to the really most depressed classes of India, the SC and ST, so there was no problem. But problem started with Mandal Commission. 1989 Mandal, 10 years later, and Mandal, by the way, did not benefit the creator of Mandal. VP Singh did not really politically benefit out of it. Then 1999, Atal Bihari Vajpayee goes to Sikar in Rajasthan, and he was the first one to actually declare that we will give reservation to Jats, after which the state chief minister of Congress, Ashok Gehlot, actually gave it. So you see, what it has done backward and forward is that Brahman and Rajput are also demanding reservation. They're saying we are also poor.
Right, but you're right. Well, those are the criteria that the court has said, that all these various criteria are involved, not just caste, as the court has said. And Mr. Mohapatra, we've heard now various Jat leaders saying that we will now take legal recourse. What are the options that are available now legally?
So legally, the option that is available before the leaders or the aggrieved parties file a review petition before the Supreme Court and tell the court that, look, this is the wrong that has been committed, because the scope of a review petition is very limited. You have to, at the first stage itself, satisfy the court that, look, there is a prima facie error which is apparent on the record, on the face of it. So the court has to be satisfied on the first instance itself that this was the, or X was the error that was committed by the court. And if the court thinks that yes, that error has been committed, then maybe the court would review it, but otherwise there is nothing. Maybe there would be a case which could be made out that since this is a two judges bench that has given this judgment, refer it to a larger bench. But however, my reading of this judgment, my understanding of this judgment rather, is that it has followed a 9-judge bench judgment that was pronounced in 92. So there could be another argument that, look, even if you refer to a constitution bench which constitutes of 5 judges, it will not be proper. So it has to be referred to an 11-judge bench maybe. So that
but as you said,
the
scope of a review petition is also very low.
Yes.
And coming to you, Mr. Mudgal, when how important would you say, again, how important would you say reservation is for the Jat community as a whole? As you said, they have taken a lot of jobs in terms of, and as also a lot of benefits they do have. Before the elections, both the BJP and the Congress, had promised them reservations. Now that the Supreme Court has quashed this notification, how do you see these parties, reacting? What are the options available to them?
You see, in the states, they can go to NCBC. See, the problem with the NCBC was that it was looking at really old figures. Now, the census in India does not take place caste-wise. So as a result, there was a time when NCBC was actually looking at the numbers, etc., and looking at the facts and figures. They were going by the census of 1931.
Right. Could the argument, that other communities have got reservations, so why not Jats? Could it be the prop on which, this movement could be carried forward?
Of the pie. I mean, how much can you cut it? You can cut it horizontally, vertically, and you can. How much can you divide? There is no doubt. I mean, I would not take a one-sided position. There is no doubt that there are poorer among Jats. There are also poorer people among Brahmins and Rajputs. So to say that some Jats are poor does not mean that they should be given reservation. If you see last 30-40 years, Jat community, it's a very progressive community. These people, they have done well for themselves, And I think they should, it's only because they have the numbers. So the politicians are trying to take advantage of the situation, and the Jat community's leaders also are coming forward and saying that we'll get you this. I think it's an absurdity which has been cleared by the Supreme Court of India, and thanks for that.
Right.
In fact, your question has been answered by the Supreme Court itself, which says that just because somebody has been wrongly included, that does not give you a right to claim on that basis.
Right, and on that note,
another wrong on the basis of the first wrong.
Rather, the Supreme Court says that it is an evolving process, which what constitutes backward class. And in fact, the Supreme Court has referred to a recent judgment which was passed by the court itself in 2014, where the transgender or the third gender were directed to be included, or the government was directed to include the third gender in the backward class. So, all in all, the Supreme Court has given a judgment for us to analyze and understand that just because of you are saying that you belong to a backward caste,
that
does
cannot
not
be the
ipso
sole
facto mean
that
you'll be included
does
in
not
the reservation
justify
list.
the demand for reservation. Well, on that note, we have to wind up this discussion. Thank you very much for joining us on the show.